the topic of race. And if you'll permit me, I'm going to try to run through some history here, a few bullet points. When the Constitution is ratified in 1788, of course, it gives the famous 3/5 clause so that African American slaves are counted as only 3/5 of an individual. But it also gives Congress the power to end the importation of slaves, the international slave trade, in 1808. And Congress does exactly that. The first chance it gets, it ends the international slave trade. After the Civil War, the 14th Amendment forbids states from denying citizens the equal protection of the laws, and then the 15th Amendment declares the right, quote, to vote shall not be denied on account of race, color, or previous condition of servitude. We get the Jim Crow regime of the 1960s, and then we get the Civil Rights Act of 1964, banning discrimination based on race in employment, public accommodations, and elsewhere. So the layman, skimming through the history, says, the founders wanted to get rid of slavery. The founders were uneasy about race from the very get-go. We see the way they handled it. I would even, if I could quote it from memory, I would. I can't. Frederick Douglass referred to the 3/5 clause as scaffolding that permitted the rest of the structure of the Constitution to be erected, but that was to be removed at the first opportunity. And again in our history, we get the assertion, no, we are not going to make judgments among our fellow citizens based on race. And then in 1978, which let's face it is a long time after the Civil War and the Civil Rights legislation, the Bakke decision, the Supreme Court holds that university policies could still take race into account. And then in 2003 in Grutter, the court upholds the use of race in university admissions once again. If I may, we'll come to Students for Fair Admissions versus Harvard in a moment, the case that got decided in 2023. But I look at this history, again, this is the layman thinking, I have no legal training at all, and it looks to me as though the court, on occasion, in Dred Scott, the court upholds racial discrimination with a snarl, the voice of Chief Justice Taney saying that African Americans do not have rights of the same kind as white men. Or, as in Grutter, the court says it in the nicest possible way, Justice Sandra Day O'Connor decision, quote, we expect that 25 years from now, the use of racial preferences will no longer be necessary. We don't like it, but for this moment, but in both cases, the court is continuing to say, all right, we find making discriminations among our fellow citizens on the basis of race to be constitutional. Why does this, it seems to me to be just as a historical matter, an unusually vexing matter. It comes before the court again and again and again. In the 20th century, the court is unhappy with it, but still permits it.
Well, the court's record on race has been up and down. And that's similar to the country as a whole. Slavery and racial discrimination was the great flaw that was built into our constitutional system at the start with the 3/5 clause, the clause that you mentioned about allowing the slave trade to continue for 20 years. And it has taken us a long time to work through these problems. So the court was horrible, and Dred Scott, of course, may have contributed to the outbreak of the Civil War. Then along came a case called Plessy versus Ferguson, 1896, at a time when social Darwinism and sort of scientific racism among the elites was at its peak, and the court said that racial segregation was constitutional. The first Justice Harlan, John Marshall Harlan, wrote the best dissent in the whole history of the Supreme Court in that case.
In Plessy.
Yes, in Plessy, where he said that in our country there's no superior race, there are no castes, the Constitution is colorblind. He was all alone.
And he was a Southerner, as I recall.
He was a Southerner, and he came from a slave-owning family. But he was courageous and made that argument, which of course was true and has stood the test of time. Then the court finally overruled, in effect, Plessy and Brown versus Board of Education, 1954. We saw the reaffirmation of the same principle that Harlan had articulated in Plessy in Dr. Martin Luther King Jr.'s famous speech at the Washington Monument, which everybody should be familiar with. I look forward to the day when my little children are judged not by the color of their skin, but by the content of their character. In Bakke, the court did some backsliding, and I think it was well-intentioned. It was perhaps thought that this was something that should be done for a period of time to try to get over the after effects of a long period of segregation and discrimination. The precedent lasted, and it metastasized, and I think it came to do great damage to our society. So it was important to correct in students for free admissions.
Let me, if I may, on that case, set it up. 2023, Students for Fair Admissions versus Harvard. In taking race into account in admissions, the court found Harvard violated the 14th Amendment and the Civil Rights Act of 1964. Chief Justice Roberts writes for the majority, quote, eliminating racial discrimination means eliminating all of it. How do we understand that in relation to Grutter, that the court decided it couldn't wait 25 years? Is that a rebuke of Grutter, that Grutter was incorrectly decided? In other words, as best I can tell, one needs to understand what the court meant in relation to Grutter to understand where the court goes from here.
Well, I can only speak to myself on that point. I think Grutter was wrong. I think Bakke was wrong. I think that our Constitution is colorblind. I find it hard to see how we're going to hold together as a country, in a country with people of every race and every ethnicity. How are we going to hold together if we don't regard each other simply as fellow human beings, as fellow Americans, and judge people based on their individual characteristics? So I think the whole path of that the constitutional law took from Bakke until Students for Fair Admissions was a mistake. As I said, I think some people may have thought this is something we should do on a temporary basis. That was the flavor of Justice O'Connor's opinion. Right. I think that was a mistake.
Well, so Justice Alito, if I may, you just made a very striking assertion, which is that you believe the Constitution is colorblind. That it, if I may probe that a little bit, it is there, I suppose that means it is unconstitutional in some large portion of the realms in which we live, professional life, public accommodation, politics in various forms. It is unconstitutional for us to draw distinctions among our fellow citizens on the basis of race, full stop.
Yes, absolutely. I think that's the core principle of the Equal Protection Clause of the 14th Amendment, and I think it's essential for the well-being of our country.